Munger from Duke.
Yeah! Yeah! Hell yeah!
You can see the title of the talk. I'm going to let him explain what that's about. But I wanted to also just say that we are really appreciative of the people who come and support us every week, and we look forward to new faces. And we started this group. When I say we, I mean myself and Professor Munger and Professor Salzman and Jenna Robinson and Theodore Hicks and Terry Stoops, because we believe in liberty and freedom and free markets. And I got a note today from somebody who said, I really want to thank you for helping to advance the cause of liberty, and that's kind of what it boils down to. And seriously, when my wife and I moved here from California to North Carolina, we wanted it not to be like California has become in terms of the Silicon Valley and big tech. It used to be entrepreneurial, and now it's transformed into a different animal. I'd like to acknowledge and honor Justice Phil Berger for being here today, and I really appreciate his attendance. With that, I'd like to introduce Professor Richard Salzman, who will say some words, and Professor Munger will make his presentation.
Thank you, Brad. It's a pleasure to introduce my esteemed colleague at Duke, who is professor of political science, economics, and public policy at Duke for, I think, more than 20 years now. So he's old. And he's taught there he's been department head too, 3 times. That's yeoman's work right there. He is a senior fellow at AIR, which is nice. Degrees from Davidson, Washington University is his PhD from St. Louis. He's taught at Dartmouth, at UT, Texas, thousands of students, if I recall you telling me, and hundreds of TAs or whatever that required. UNC, many, many books. He's incredibly prolific. He's a great speaker. Just the 3 most recent books: The Sharing Economy, Its Pitfalls and Promises; Tomorrow 3.0, Transaction Costs and the Sharing Economy; and Is Capitalism Sustainable, 2019, also AIER. So I've known Mike now for 15 years. He's one of my heroes. I keep another colleague who's also a hero. That's I think you'll enjoy the talk. He's eloquent, he's witty, and it's obvious he's also handsome. So, Mike, is that enough?
Well, thanks. That was completely uncalled for. You can tell someone's important when it takes 2 people to introduce them, so thank you. This is a book project that I have been working on. And one of the ways that I work on a book is to go around and give talks and have people tell me ways that I could do it better. So I'm counting on the sort of hive mind. Y'all have some experience working in business and maybe working with the antitrust authorities. I have an embarrassing admission. I myself have some experience in working with the status quo in antitrust policy, which is the consumer welfare standard. So we have come to a policy choice about the way that we'll enforce antitrust. And as evidence of my experience, so there I was. I worked at the Federal Trade Commission. There may have been drugs involved. This was the early 80s. I want to get an amen from Bill Easley. I mean, it's just the way things work. So we're going to skip on from there. But Douglas Ginsburg, who many people know from the Law and Economics Center at George Mason, so federal judge Douglas Ginsburg, claimed up until the time that the consumer welfare standard was implemented 40 years ago, the U.S. Supreme Court simply did not know what it was doing in antitrust cases. It was a hodgepodge, a discretion. the sort of unknown standards, which means that businesses were put in the position of not knowing in advance whether an attempt at a merger or acquisition or the contracts that they were writing would be accepted by the antitrust authorities. And then discretion was used in ways that were usually opaque, a kind of star chamber. So the goals that were listed including protecting rivals, protecting small producers from predatory pricing, encouraging many firms, preserve and expand employment, an entire dog's breakfast of possible social goals held by judges, and an attempt to prevent vertical and tying arrangements in contracts. So a lot of contractual arrangements that businesses wanted to make in order to improve the quality of service delivery or make sure that the customer service representative at their store was well trained, they could not do because that was resale price maintenance. So a little bit of history for antitrust. From the founding through 1890, contracts and agreement in restrictive trade were restricted only by common law limits. So there's a famous book by Bartholomew in 1923 on enforceability, and it's interesting that they had come to this. So if two companies tried to write a contract in restraint of trade, maybe we're both milk producers, and I say, look, we're playing golf. I say, look, we're killing each other, cutting price. Why don't both of us keep a price at a certain level? Because then we'll be able to sell our milk and we won't have this destructive competition. And you say, sure. And so we write out a contract and we sign it. And then within a week, you're saying, you know, if that moron is going to charge that really high price, I can just cut my price and make a lot of money. So you do that. And I say, you sorry sack of concrete. And I sue you in court. And the judge throws it out because that contract is not enforceable. And the fact is that under most circumstances, attempts to negotiate agreements in restraint of trade, if they're not enforceable, are unsustainable because the incentives to cheat and to have competition in cartels is just so overwhelming. So that, for 100 years, had been the tradition in common law. The United States, in the beginning of the progressive reforms in 1890, decided that we could do better. And the way that we did better was to pass the Sherman Antitrust Act, which has 2 clauses. One of them outlaws structure, and the other outlaws particular kinds of conduct. So the clause that outlaws structure would say that if a company is a monopoly or moves to achieve monopoly, then that is per se illegal and it can be broken up. Conduct is an attempt to achieve monopoly either through contracts or other things. It's much less vague. So between 1890 and 1920, after the passage of the Sherman Act, the conduct of business and the structure of the industry were the things that were being regulated. So that duality was then extended by the enactment of the Clayton Act and the Federal Trade Commission Act, which were specifically conceived first to break up and then to prevent the formation of trusts and monopolies. Now, in defense of the regulatory authorities, let me say, you notice, and this is sort of an R.H. Coase solution, you and I have a contract in restraint of trade. It's not enforceable in the courts. But if I buy you, I can make decisions for the combined company and raise the price, and there won't be any problem because that contract is enforceable because I bought the company. Now there's an intermediate step, which is we can combine our assets but retain separate management in a legal organization called a trust. So the companies are still separate, but they're managed jointly because there is a trustee. And that's another way of circumventing the fact that you couldn't get an enforceable contract in restraint of trade. And some of the trusts, which at that time were famous, were Standard Oil, American Tobacco just a little bit later, the US Steel. These were many companies that had combined effectively into one. And of course, as soon as they did that, they immediately raised the price. Not. In fact, what's interesting is that the evidence over this period is that these trusts were constantly lowering price throughout the entire period. The railroads, steel companies, tobacco constantly reduced prices. So you really have to tell a difficult story to say why this is a problem if you're worried about consumers. So there's this company that's delivering better and better products more and more cheaply. Now, it is true that that's very inconvenient for competitors who suck. I have to charge a higher price. This isn't fair. My quality's not as good. This isn't fair. Well, that's just the sort of unfairness that capitalism is supposed to foster. That's creative destruction. That's the reason why, from the very beginning, consumer welfare was thrust aside in favor of the dog's breakfast of other objectives. Because we want to be able to protect competitors. Why, I ask you, my voice rising with indignation. Why? Why would you want to protect competitors unless they're raising price? I get that. If you're trying to achieve monopoly so that you can raise price, good on you. But if the price is falling, or you're using contracts to maintain your ability to deliver a better product and better customer service, shut up. Well, 1921 through 1940, after the Wilson administration, antitrust activity was relatively rare. And in fact, during the New Deal, the Roosevelt administration found that concentrated industries were much easier to regulate. So allowing industries to combine, firms to combine into near monopolies was actually encouraged because it was easier to have a kind of bilateral monopoly regulatory scheme between government and business. Between 41 and 77, there was a kind of dialectical response. Having nurtured government now said that there's a crisis which we have to manage. So all these monopolies which had been created by a government partnership now had to be regulated. So it was said that the antitrust had come to represent the Magna Carta of free enterprise. So it was the basis for arranging industry structure. Mature businesses sacrificed the fluidity of mergers and acquisitions, but they got state protection of market share. That's just fine. If you guarantee me that there will be no competitors that enter my industry, I'm willing to give up a lot of fluidity about my own pricing and investment decisions. But then 1978, we get the Consumer Welfare Standard, which was championed, in part at least, by Chicago's Robert Bork in his 1978 book, The Antitrust Paradox. Now, Robert Bork was treated when he was, there was an attempt to appoint him to the Supreme Court in 1986 as a kind of, or 87, as a pariah. But in fact, at least in antitrust, his policies were not especially radical. The after merger structure that he advocated for was no fewer than 3 firms in an industry. So the Bork test in antitrust was you look at the industry post-merger or post-acquisition. If there are fewer than 3 firms, then okay, maybe it's a problem. But if there's 3 or more firms, it should just go through. Now the advantage of that is that it's clear what the law is. If I'm considering a merger or acquisition, I have some hint of what the antitrust authorities are going to do. I can plan. Capitalism requires an ability to plan, not the imposition of ex post facto laws at the whim of the regulatory authorities. That's where we're headed back. So the case that actually changed things was Continental TV versus GTE Sylvania in 1977. The simple facts, and I am simplifying, but the simple facts are that Sylvania wanted to have its TVs sold only in places that had trained customer service people who could answer questions about the television. But even then, it was fairly common to go into a place, and if they were stupid enough to have hired competent people, ask a bunch of questions, and then go somewhere else and buy it at the cheap place. I know none of y'all have ever gone into a hardware store and then bought it online. But there are people who do that, believe it or not. So Sylvania said, if we do that, we cannot have well-trained salespeople. And so we would like, as a decision, this is a competitive industry. There were a lot of different companies that were selling televisions. The claim was that the contract itself was a per se violation, that it was a violation of the law against contracts, of resale price maintenance contracts, even though both industries are competitive. Now, the decision was that interbrand competition is the primary concern of antitrust law. Congress designed the Sherman Act as consumer welfare prescription and a restraint that has the effect of reducing the importance of consumer preference and setting price and output is not consistent with this fundamental goal of antitrust law. So the evolution toward consumer welfare standard and away from non-economic considerations has benefited consumers and the economy much more broadly. So we have had predictable law since 1978. The welfare-based standards, that is consumer welfare-based standards, eliminate a lot of need for litigation or applications for waivers from the regulatory authority. So no theories of liability. That is, you have damaged me by charging a lower price. Of course you did. That's the essence of capitalism. No defenses where the restraint of trade is necessary to save consumers from the consequences of competition because competition is good for consumers. And we no longer have the per se illegality of all these contract provisions. So, while not perfect, at least since 1978, the antitrust laws that we have are at least workable. So, what we're seeing now, I've written a couple of things where I said the left has discovered originalism. Except their definition of originalism is to look at the legislative debates leading up to the passage of the Sherman Act, where some senator who wanted to get this in the congressional record so he could brag about it back home says something about, there's a business in my state that actually had to compete against a big city company, and they charged lower prices, and it's not fair. Well, that had nothing to do though with the law that was passed, but if you look at that, then we have to protect labor. And look, the people who passed this, they were worried about labor, and so that was the original intent of the Sherman Act. Let us restore that. So the left has discovered a strange kind of originalism. They want to go back to what they claim is the original intent of the Sherman Act. And we're seeing a counter-revolution of prescience, where somehow judges can see the future. They can make choices about which firms are likely to succeed and which are likely to fail, so that even at the time of a merger or acquisition, the structure of the industry is competitive. We all know that it's going to become much more concentrated, and so we're going to nip this in the bud. So it's actually probably right. They're actually probably right. The Sherman Act was explicitly intended as an industrial policy with all of the bad things that that means. Instead, now the US has an industrial policy. Any capitalist country has an industrial policy. What is it? The system of profit and loss. The companies that earn profits after paying an opportunity cost rate of return are showing that they produce enough social value that more should be invested in them. And companies that lose money are destroying social value and should go out of business. Over time, the industrial policy of profit and loss will produce a vibrant, active set of new firms and industries. If you think you can do better than that, then you think that a bureaucrat who has no information about price or profit and loss can make forecasts about which new alternative energy fuel, which sustainable energy is going to do better than fossil fuels. So we've seen a number of disasters recently where companies that have made solar panels have gone bankrupt. It turns out that if you're worried about climate change, the most that you should do is put a tax on carbon, because you can't guess what alternative fuels are going to work. If you're worried about the externality, tax the externality and then let companies fight this out on their own. Now you might think there's nothing to do, but that's not what we're doing. What we're doing is subsidizing a large number of new alternative energy companies. So the examples of attempts to change the consumer welfare standard, as if judges could see the future, include a better deal from the Senate Democrats, Giants Among Us, there's a law school paper, University of California, Hastings, and that was actually the Giants Among Us kind of struck my fancy, so that was also the title of this talk and probably of the book. Lena Khan, who is now amazingly the Chief Commissioner of the Federal Trade Commission. It's just remarkable. Took Robert Bork's antitrust paradox and then talked about Amazon's antitrust paradox. The majority staff report for the House Committee on the Judiciary published this investigation of competition in digital markets. And my ex-colleague, and I know you Duke folks are proud of Zephyr Teachout, she is remarkable. She now works for the New York Attorney General. And her solution to pretty much everything is to have the government run it. And I think not very long ago this would not be taken very seriously. And now it's not only being taken seriously, but it is the dominant thread of the idea of how Democrats would like to conduct industrial policy and antitrust policy. And the idea is, let's break them up. Let's break them all up. So how many companies should there be in an industry? Well, one answer would be the system of profit and loss will tell us, provided that there are no violations of the Sherman Act that would be an attempt to monopolize. An alternative would be more. There should just be more. That we should value consumer choice for its own sake. It is better to have 10 bad, expensive choices than 3 good, cheap choices. And I'm not making that up. Seriously, let me say it again. It is better to have 10 bad, expensive choices than it is to have 3 good, cheap choices. That's the impetus behind the originalism that the Democrats have taken up, particularly in the Senate, that the Democrats have taken up for antitrust. So, Zephyr, famous, I follow her on Facebook. It's very amusing. Forgive me, on Twitter. So Facebook and Google want to keep playing 3 roles: essential infrastructure, publisher, and targeted ad mogul. That's impossible in a democracy. The government has to force them to choose a new business model, or rather, it has to choose for them. So I didn't want you to think I was making this up. That's Zephyr. Now, there's a communications professor named Daphne Zeller at Stanford, who is a left of center person herself, but is just amazingly good on these sorts of policies. So what Professor Keller said was, when you write about the internet as if it were only Facebook, Google, and Twitter, you help to create that version of the internet. The reification goes like this. Journalists, academics, and other storytellers depict an internet with only those few companies. Lawmakers accept that framing. They pass laws that assume only the existence of the giants and work only for them, and the internet changes. So if you think of an industry as the large, mature companies that are actually on the downhill glide path towards end, you miss all the dynamism that having an open antitrust policy creates on the front end. So I didn't bring it here, but I actually have, it was in the Atlantic, an article that was just outraged about we're never going to be able to get rid of this monopoly. This social media company controls almost everything, and it was in 2007. They were upset about MySpace. Typically, as soon as the authorities are upset about something, it's on the way out. Because the new companies are already moved somewhere else. So Daphne Keller has this right. If you start to think in terms of those structures, why was it that Bell Telephone was broken up? To prevent monopoly. So what we got was 50 state or regional monopolies that actually prevented the beginnings, as Tom Hazlett has shown, had prevented the beginnings of a competitive telephone industry in the United States for at least 20 years. And there was no reason to have done that except that we were trying to control monopoly. And so what we created instead was a set of utilities in an industry that should have been dynamic. A utility, by definition, they're forced to be this. I don't blame the utilities, but a utility, by definition, is not negotiating with consumers. They're negotiating with the rate commission. So there's no prices. There's no consumer welfare. This is just bureaucrats negotiating with bureaucrats. So the challenge of antitrust, this is the report of the majority staff of the House Subcommittee on Antitrust, Commercial, and Administrative Law, from Ciceline is the chair. These are verbatim quotes. Again, I don't want you to think I'm making this up. The subcommittee suggests that the Congress consider non-discrimination rules that would require dominant platforms to offer equal terms for equal service and would apply to price as well as to terms of access, which means that all of their prices would be subjected to scrutiny and approval by bureaucrats. Couldn't make pricing changes, and by their nature, these are highly fluid, dynamic companies. Shifting presumptions for future acquisitions by the dominant platform. Under this change, any acquisition by a dominant platform would be presumed anti-competitive. Not all of you have legal training. If you reverse a presumption, if it is presumed to be anti-competitive, it means any time I want to have any kind of merger, acquisition, or new contract, I have to hire a bunch of attorneys who put together an application which, until it is approved, I can do nothing. So reversing the presumption means that I can't go ahead, and then they'll say whether it was okay. Ideally, I would be able to tell whether it's okay, because there would be a law. I read the law and I can tell, I can do this, I can't do this. If I'm doing 80 in a 65, maybe I think the cop should let me off, but probably not. 80 is a lot more than 65. That's a black letter law. Antitrust needs to be something close to black letter law. So we're reversing the presumption. They want to reverse the presumption, meaning that all mergers and acquisitions would be presumed to be anti-competitive. And I'm not paraphrasing. That's their words. Prohibiting the abuse of superior bargaining power, which, remember, bargaining power is I have a lower price than you do, including through potentially targeting of anti-competitive contracts and introducing due process protections for individuals and businesses. So it's not just that I have to ask the authorities if I can have a merger, I have to ask my competitors if I can charge a lower price. Do y'all mind if I charge a lower price than you? Well, yes, actually, we prefer you did not do that. Reasserting the, and there it is, original intent and broad goals of the antitrust laws by clarifying they're designed to protect not just consumers, but also workers, entrepreneurs, independent businesses, open markets, unicorns, a fair economy, and democratic ideals. What the hell does even democratic ideals mean? So, they're not clarifying what the original intent is. They're asserting it, and they want to pass it into law. Explore presumptions involving vertical mergers, such as a presumption that vertical mergers are anti-competitive. So remember, we have a firm in an industry that is competitive. They're not a monopoly. And we have another firm that sells upstream or downstream to that company or buys from that company. If I buy my supplier or I buy my downstream retail outlet, that is per se anti-competitive. I would have to get permission from the authorities in order to do that. Whether making a design change that excludes competitors or otherwise undermines competition should be a violation of Section 2, regardless of whether the design change can be justified as an improvement for computers. So for consumers, I'm sorry. So I'm building a computer, and I'm going to change the software in a way that will make the operating system much better for consumers. I have to ask the authorities, and they'll say, why are you doing this? Well, it's actually a much better product. Well, what will happen to competitors? Well, it'll probably be bad for them because our product will be cheaper. Oh, no. No. But it's better for consumers. I'm sorry, you need to read the new law. You're thinking of an old-fashioned way of doing this. So, in this view, the loss of a choice for consumers is lexically above, or more important than, considerations of total output or price. So the argument can be based on the existence of the choice or on consumer surplus. So, those of you who are a certain age remember this comparison. None of the young people do. I should say that at one time there was a thing called cassette tapes. And it was sort of after 8-track tapes, and there's still some vinyl albums, so you've seen those in museums or your parents' closet. But there was an invention, an MP3 player, that did an amazing thing. It divorced music from the medium on which the music was pressed or imposed. So if I said I was going to go buy an album, I wasn't actually buying an album. What I wanted was the music that was on the album, but it was difficult to separate those two things. Now, it was possible sometimes to take something from an album and tape it onto a cassette tape. But the creation of the MP3 player meant that digital music was now entirely independent from the medium on which it was stored. It could be infinitely reproduced. And it could be, because improvements in memory had been made and improvements in battery had been made, it was very portable. And I could have dozens and dozens of albums on just one iPod. So the iPod was revolutionary. This is the old person part. That's a Sony Walkman. And y'all are cool, I can tell, or you were. And so a Sony Walkman with these big clunky earphones, you could play a whole cassette tape. And it had two sides, you could turn it over. So it had quite a bit of music on it. What happened to Sony when Apple introduced the iPod? They lost $60 million in their stock price in about a week. And they had to lay off 10,000 workers. Should that have been illegal? It would be if we get the new antitrust law. They had produced a new product. Now, probably it would have been approved because it is clear that it is a better product, it's cheaper, it's different. Bureaucrats don't hate people. They want what's good for all of us. They've assured me of this. So it probably would have been approved in just 2 years. So it would have been 2 years later before we get the iPod, and presumably Sony by that time would have designed some competing product. But those 10,000 people wouldn't have lost their jobs, and that's the way it should be. I just hate people, apparently. Because I want this only to be about consumer welfare. So the Senate Democrats in 2017 published a better deal. And I'll go through this just quickly because I want to talk a little bit about platforms. We're going to 8:30, right? I wanted to see that. I wanted to see that terrified look. So the goal is to establish a strong legal presumption that market concentration is anti-competitive conduct. That is, structure is conduct. Antitrust must not only prevent mergers that unfairly increase prices, but also those that unfairly reduce competition. If you have a company that sells something that a lot of people like, you'll have a large market share, and you have to be punished for that. They wanted to establish antitrust must not only prevent mergers, so in the bottom part's the important. In an increasingly data-driven society, merger standards must explicitly consider the ways in which control of consumer data can be used to stifle competition or jeopardize consumer privacy. I have some sympathy with this. So if I'm on Facebook, I'm on Google, I'm on Amazon, I don't really own my data. I am surfing the internet, S-E-R-F. I am a serf on the internet. I'm throwing off valuable data because I am working on the fields of the manor house. Now, the question is, how might we do anything different? So if I'm on Spotify and I create a set of preferences about my music, which their bots can then use to make judgments about other music I'm likely to like, and a new music sharing program comes up, I cannot transfer those embedded preferences from Spotify somewhere else. So there's some really interesting property rights problems here. So the new company might be better than Spotify, but it would take me a long time to build up all of the information that I have on Spotify as a sunk cost. That's not an antitrust problem. That just means that Spotify is really good and really useful. The fact that I use Uber a lot, or I use Airbnb a lot, and I have a reputation on those platforms, is a sign that those platforms have solved the problem of the asymmetry of information that underlies trust and assurance in a way that's really important. Breaking up those companies will not solve that problem. So, jeopardizing consumer privacy is potentially a problem. I want to raise a question about that, though. So let me talk a little bit about platforms. So I have claimed that platforms are any organization that solve the three essential problems of human cooperation: triangulation, transfer, and trust. So an example of a platform was the souk in Aleppo in 2000 BC. And the souk was a big marketplace. And when you think about it, if transactions cost weren't important, it would be a strange thing for me to do. So I spend a lot of time growing grain, and I get 3 bags of grain, 3 large bags of grain. That's the entire produce of my family's farm for the year, and I take it, and I want to sell it so that I can get some of the things I need for my family in Mesopotamia. Now, where should I go? I should go out into the middle of a field where no one else is, because that's where the fewest competitors will be. And say, grain, I've got grain. And after about an hour, I think, well, hell with this. And so I go to the souk, even though there's a bunch of other sellers there. So there is a kind of competition, but the advantage is that the souk provides a platform where there are many buyers and sellers, where there is the ability to deliver the product and take payment, and there's some kind of security surrounding the place so that my goods won't be stolen and my money won't be stolen afterwards. So another example of a platform is the Sears catalog. The Sears catalog was the first virtual platform. It was virtual on paper instead of being online. Not long after that, Amazon was an actual virtual platform. What did Amazon sell when they first started? So remember, there was a sequence of bastards. First, there were small independent bookstores. Who were the bastards? Barnes & Noble. And now Barnes & Noble are the good guys, and the bastards are Amazon. Except nobody even thinks of Amazon as a bookstore anymore. Amazon sells all kinds of stuff. Why? And the answer is it's a platform. Their ability to put together triangulation, transfer, and trust meant that they could sell all sorts of different products. It didn't have to be just books. The difficulty is that a successful platform which solves the problem of peer-to-peer sales, that is, buyers and sellers find each other on my platform. Why did I go to the souk? Because I can find a seller. Does the souk buy? Does the souk sell? It does not. It provides a location where buyers and sellers find each other. Does Amazon buy or sell? Well, Amazon does produce some products, but mostly Amazon provides a virtual souk where we, buyers and sellers, can find each other. So suppose you broke them up into 3. That's stupid. It's just harder to find each other. By its nature, platforms want to be giants. In an evolutionary sense, platforms want to be giants. The best one of these is where everybody is going to take their stuff, particularly in a virtual world. So the problem for antitrust policy is that giantism is a sign of success. And if you have a policy that explicitly targets the best and most successful, you'll have, well, what the Senate Democrats want. So a platform is a place that supplies substantial reductions in each of the 3 aspects of transactions cost. Triangulation is information about identity, transfer is a way of making payment and picking up the good, and trust is a way of outsourcing assurance of honesty in the performance of terms of the contract. So the souk, you rent a stall there. The souk makes money by renting space. They don't care what you sell. Which spaces in the souk will be rented? If they're limited, or if some places in the souk are better than others, the best places, or the places at all, will go to the people who expect to make the highest profits from renting those. which means that they expect the most people to want to buy their product or their service, which means that the system of profit and loss will organize the soup to produce the maximum social value in a way that no individual could possibly have foreseen or forecast. The result is a social plan that is far better and more comprehensive than any individual could possibly have planned it, and it takes place with nothing more than the souk saying, stalls for sale, and if you want to buy stuff, come here. That's all that's required. And you end up with what looks like a highly planned society. Well, there used to be a thing called malls. And malls were the sort of intermediary between souks and Amazon. The Sears catalog is particularly interesting. Mr. Sears owned a railroad company, and he wanted to have more cargo for his railroad company. Mr. Sears came from the Midwest and thought in terms of small Midwest towns where a hardware store might have no more than 20 or 30 items. And the seed and feed really wouldn't sell much more than seed and, well, feed. Because that was all that was available in the local area. How many different things were available in the Sears catalog? 10,000. So you could find some. What was Sears selling? Sears wasn't selling any stuff. Later, Sears stores became a place that actually had Kenmore, and they had brand names. But the Sears catalog is just a souk, but it's a virtual souk that is on paper. But it's literally virtual in the sense that buyers and sellers can find each other. Sears provided the transportation, and you had reviews. You had the beginnings of reviews, which meant that the problem of asymmetric information about trust could be solved. If you acted badly, Sears would not sell you an ad next time the Sears catalog went out, which was a severe punishment for someone who needed the Sears catalog in order to provide a place to sell its products. Now, some of the things that they sold were a little bit odd. There's a variety of petticoats. I'm actually not sure what this is. This was in the Sears catalog. The guy is pretty hot. But it's an electronic thing, and it goes down in front. I'm going to skip that. They sold houses. You could get a house delivered. So pretty much anything that somebody thought they could sell. So it's like the stalls at the souk. I would buy a space in the Sears catalog, and if I was wrong, I lost money. If I was right, I made money, which meant that the society needed that thing. Who knew what society needed? The Heidelberg belt, I think, probably didn't last very long, but maybe I'm wrong. Maybe it helped some guys out. So we have modern malls, Amazon, Facebook. Wikipedia is a platform. Doesn't Wikipedia have a monopoly on Wikipedia? Shouldn't they be broken up? What's the nature of platforms that they will be giants? We're running into a problem where antitrust misconceives the problem. And of course, Uber. So, a hint, an aside, Amazon used to sell books. What does Uber sell? Uber delivers things. Uber is a platform that solves the problem of triangulation, transfer, and trust. So if I needed a power drill, I could go to Uber, scroll down, order the power drill to be delivered to a smart pod in front of my house. 5 minutes later, it is delivered by an autonomous Uber car. I go, I get the power drill. I drill 2 holes in the wall where my wife wants to hang a picture. She says, not that wall. I drill 2 more holes in the wall and think about the spackle I'm going to need. I put the drill back in the smart pod, and another Uber car picks it up and takes it to the next user. That commercial quality power drill is used 10 or 12 times every day. Uber is a delivery platform. The fact that right now it delivers human beings is like Amazon delivering books. It has nothing to do with the value proposition of Uber. The big fight is going to be between Uber and Amazon, or something like Uber and something like Amazon. That's the conflict of the future if we don't mess it up by imposing regulations or breaking them up. There is competition. There is competition for delivery. Amazon delivers stuff to be owned. Uber delivers stuff to be rented. Uber is going to take advantage of the sharing economy, which is the commodification of excess capacity. The commodification of excess capacity. Most of the stuff that we store, if we could rent it out. And Uber and Airbnb are two of the best examples. If I have a car in a few minutes and you need a ride, or if I have an apartment that I'm not going to use for a month, I'm not storing it, I can rent it out. So the middleman economy wants to sell reductions in transactions costs. The sharing economy wants to sell access to excess capacity. Which means that we're going to get giants. So the argument that I've made is that platforms, if they're successful, will always tend towards giantism. So I want to propose, and this is just off the top of my head, let's suppose we're worried about giants. If we check at least the 3 of these things, then they're a giant. Produce or contract for exclusive ownership of their own content, send out that content on a medium characterized by substantial scale or network economies. They operate in 2-sided markets where most participants are both content providers and consumers. I know you young people don't use Facebook, but for old people, on any given day, I may look at someone else's cat pictures, and they may look at my dog pictures. So I'm both a content provider and a user. On TikTok, I may be someone who looks at videos, but also someone who puts up videos. So it's a 2-sided market where our position of provider or consumer is fluid. They may be vertically integrated. They may operate in a setting where the producing entities are few, which allows Ostrom-style solutions of collective action and common pool problems, which means that larger, more inclusive institutions are always going to be more efficient. This is just ill-suited by its very nature for antitrust. So my friend Bill Shugart on Twitter said, I wish, I'm not making this up, I wish a group of authors on Medium would get together and form a coalition and then offer a reduced subscription price. And then I could read them all together. And George Vanberg says, we could call that a magazine. Well, that's existed for a long time. And Bill wasn't that happy. So, traditional mainstream media platforms are not 2-sided markets. Usually mainstream media are providers of information. There are costs of publication, curation, and verification. The costs of publication are how much does it cost me to provide the thing. And if it's expensive, I'm less likely to do this in a way that's going to be wasteful. So it's the problem of spam email. Even if you had to pay 1/10 of a penny, we might be able to solve the problem of spam because publication is free. On Twitter, sending things out is almost free. Curation is what's important. Verification is what's true. So, I'm going to skip over this part, but pamphlets, I want to plant this in your mind. The first thing that was really, that Gutenberg first did with the printing press was a calendar in 1448 that was widely successful. There were many publications in the 15th century that look a lot like Twitter now. So pamphlets were anonymous, extremely cheap to produce. You couldn't tell if they were true, and you sold more of them if they were hysterical. So it was cheap, there was no real copyright protection. They used clickbait. In effect, they used clickbait. Instead of clickbait, it was clickbait. They'd have a whole bunch of them, and so you see all these different titles. This one says, a rehearsal both strong and true of the heinous and horrible acts committed by Elizabeth Gale. I want to read that. I mean, who knows what Elizabeth did? Or a discourse tending to prove that it is probable there is another habitable world inside the moon. So this is in the 15th century. This is 15th century clickbait. If you don't have institutions, big institutions that have a reputational reason to solve the problem of publication, curation, and verification, you will get an out-of-control system of the delivery of information. So if there are many small, anonymous publishers, you will have no idea what's important and you'll have no idea what's true. Now, the mainstream media solved this problem. This is King Charles, his speech from the scaffold, immediately before his execution, ripped from the headlines. So, let me skip to this. The mainstream media was very happy with having a solution that involved giantism. In fact, the three so-called major networks, and again, it's hard for young people to believe, but the three major networks that competed with each other, they were all oligopolies, and they were really big. And when Walter Cronkite spoke, it was like Mount Rushmore was speaking. This is the voice of truth. But to be fair, there was something to it if they published something that was false. It was embarrassing. It actually reduced their brand name. So what we had was a setting where if you switched channels on the nightly news on ABC, NBC, and CBS, they were all covering the same stories, probably in the same order. Now, they had different coverage, and they were competing with each other to see who could do a better job. They had a particular slant. It's not as if it was fair in any sense. But the increased competition has gotten rid of those giants. Whereas now, the mainstream media is a balkanized group, most of which are talking just to each other. I expect that we're going to see a new set of institutions that are going to solve the problem of publication, curation, and verification. They're going to be giants, just like Walter Cronkite was. So, let me go to here, and then I'll knock off. So, is bigness alone a defense? Now, I have to admit that when I was in the Federal Trade Commission, we had a definition of monopoly. It's complicated, but let me just wake up for a second. So there's a merger that has been proposed. We would rank all of the firms in the industry post-merger, from largest to smallest. After the first firm, we would draw a line. If there were no more, it was a monopoly. That's an economics joke. Which economics jokes by definition are not funny. It's a monopoly if there's one firm. If there's more than one firm, it's not a monopoly. That is a law people can understand. Remember, Robert Bork said 3. Okay, maybe 3 is the answer. But the big problem is defining the industry. So 7-Up was going to merge with Pepsi. What's the industry? Stuff you drink. They have a tiny share of stuff you drink. Sweetened, carbonated beverages. They have a pretty high share of that industry, which is the appropriate industry. There's a company that has 30 million unique daily users. They censor content. I myself have sometimes tried to send them stuff to get them to publish some of the things that I wanted to write. They said no. They will remove comments they disagree with. Should we break up the New York Times? The point is that every company is going to be a monopoly of the platform that they are providing. So the idea that giantism is a problem is archaic and destructive. Antitrust is the wrong approach to try to solve this problem. In fact, it will make it worse. I don't believe that many of the people that are proposing changes in antitrust are doing it honestly in the sense they think it will improve the performance of the economy. What it will do is put them in a position of power so that they can design an industry structure that will achieve a set of social goals more easily. So antitrust is a stalking horse to allow them to do that. Well, I appreciate your attention. I'd be happy to have questions.
Mike, in terms of everything you said here, in terms of the history of antitrust and advancing consumer welfare, and using almost all the arguments you made, my conclusion is you abolish antitrust. You don't reform.
How's that working out, Roy?
Well, how's your reforms working?
Go back to
How are any reforms that have happened?
defend the consumer welfare. That's the status quo. Defend the castle.
I'm sorry.
Defend the castle. Consumer welfare, the consumer welfare standard is the status quo.
Mm-hmm.
We can defend that.
Let me ask, if we never had an antitrust law, starting with Sherman antitrust, would the consumer be better off or worse off today?
Better, and no one cares. It's a political equilibrium. We live in a democracy.
Then why talk about reform at all? Because
I'm not reforming, I'm defending the castle. It is very frustrating. I admit that it's very frustrating. It would be great if people, I'm running for office right this very minute. I am running for North Carolina Senate District 13. It's not going to go very well. Roy, you are welcome to run for office. But it turns out people are not persuaded by our arguments. The most we can hope for is to defend the castle. And I think we're going to fail at that. I'm sorry though, I interrupted. I was being
No,
clear.
it's just kind of then
Of course we'd be
you're
better.
being defeated. So.
We would be better off if we had not had an antitrust policy. If it hadn't been passed in 1890, it would have been passed in 1892. And in fact, a bunch more would have been passed. Because the political powers of cronyism and defending these competitors instead of consumers, it's just too hard to organize consumers. So I don't disagree with you at all, but I do find well, why don't we just do and then something that involves a miracle is frustrating to me.
Yeah, okay. But is that a reason given that we know the public choice problems of having antitrust law, is that a reason to say, well, let's keep it in place when we know that no matter how we reform it, kept in place, it's still going to be riddled with rent seekers?
It's been okay since 1978. It has been okay. Of all the stupid things the government does, antitrust policy has not been bad since 1978, which is a very long period.
First, I have to say that I'm offended that you say that since 1978 is a very long period.
I got called old in the introduction.
But my question is, you didn't ever use the term natural monopoly. Is that because that term is passé now, or is it because there's an economic definition that I'm missing?
I want to double down and say all platforms are natural monopolies. That actually, it would have.
You didn't use the word, so I'm just curious.
Right, no, it would have been better if I had all platforms. The New York Times is a natural monopoly. Should we make the New York Times a utility? Should we break it up? No and no. So natural monopolies, given copyright laws, when you're talking about the provision of information, they're all going to be natural monopolies. They have to be. Amazon is a natural monopoly in the sense that they control their platform. So now I'm going to go with Roy. If the term natural monopoly had never been invented, we'd all be better off. Of course, the optimal industry structure is one firm if the economies of scale are large enough. And there may be problems with that, but the problems are not so severe that they can't be made much worse by government.
You mentioned earlier in your talk that the consolidation of companies often led to lower prices. Do we have evidence of the disintegration of those industries raised prices?
The prices went up, and there were more jobs. So most of you probably know the probably apocryphal Milton Friedman story. Goes to China, there's a bunch of people working with shovels on a dam, and he says, well, I realize you're making this dam, it's a lot of work, why don't you use bulldozers? Oh, it's also a jobs creation program. we'll take away their shovels and give them spoons. So if you create a lot more jobs, then that's a benefit in and of itself. So the fact that prices went up is one of many things that we should be concerned about, but only one of many things we should be concerned about.
On a platform, I read that you presented or talked about the sharing economy with the UN or a UN organization. How did that go? Were they receptive to it? How does this work in an international context?
There is a plurality of UN people who listen to Econ Talk and scheme about ways to try to get less bureaucratic solutions. So it really surprised me the extent to which, now they have to do it mostly in secret because their job is to try to run things. But I was really surprised at the extent to which they wanted to advocate. And to be fair, we have a lot of allies on the left. Sometimes I'll go and give talks at urban planning conferences. And one of the planners will come up during a break and say, if I could, I would get rid of all the buses, and just use Uber vouchers. Everybody would be so much better off, and it would cut my mass transit budget in half. But I can't do that. Can you tell me a way that we might go in that direction? Because that guy actually just cares about poor people. He has no religious affiliation with mass transit or light rail. So there's a lot of people at the UN that are like that also. Not a majority, not even like more than 10%. Obviously they select, but they are trying to get people to suggest more efficient solutions because many of them actually prefer good outcomes to ideologically selected input. So we have a lot of allies if we try to operate at the margin. Instead of saying government is always bad, we should get rid of it. Government is always bad, but we're going to have to work on it. It's just a given. So I'm an incrementalist, I am a directionalist rather than being a destinationist.
One of the things that really struck me was when you cited the language from the subcommittee it was either the House or the Senate, and the language was so theoretical, not at all based on any kind of examples. I mean, obviously that's kind of what legislation is, but then the next step to that also just really became clear to me was you just have this very small cadre of people who are trying to basically say the way that the economy should work or the way that we should presume markets should work. It's just such, like it goes back to your statement, it's such a locus of power outside of the market, outside of people's ability to just transact and have a free market.
Well, but so their claim is they're smarter than we are, and suppose I grant that. For the sake of argument, I will grant. But the fact is, no individual could be smart enough to do this. It's actually literally impossible. It's not hard. So I think that's where we come down to disagree. It's not a question of training people, getting better computers. It's literally impossible. So when you say free market, you usually make some argument about liberty. One of the advantages of the Mises Hayek approach was that their claim was that this is literally impossible. And remember that they did that long before the collapse of the Soviet Union, and now the collapse of the Russian authoritarian military is making that clear that it's been true all along. So we need to make empirical arguments and not theoretical arguments, or I should say not just theoretical arguments, because the empirics are actually on our side.
Yeah, I have a question to follow up on the international aspect. So if there's a monopoly that's in another country, say China, what are your thoughts on that? Like if they're the only producer of semiconductors or something like that, and so the United States doesn't have a company they don't have that competition anymore. I mean, does that change your thoughts on antitrust?
Well, let me give a short answer, because that's a great question, and it's one on which I've at least changed my mind a little bit. A friend of mine named John Pelson recently wrote a book called Wireless Wars. wireless wars, and actually he was just on Tucker Carlson talking about this. And his claim is that China in particular and the government-controlled monopolies in China are just different. So my claim is that the world also, antitrust laws, I want to claim the world would be better off without borders. So I'm willing to go really far on completely fanciful unicorn things. Now, we need borders for all sorts of reasons, but the world would be better off without borders in the sense that competitions among nations, when human beings are basically cooperative, the world would be a better place. And I'm just imagining a miracle happens where nations stop fighting with each other. I admit that. But Chinese corporations are working for world power as much as they are for economic dominion. And I was really surprised at the way that John Pelson documented this in Wireless Wars. A lot of the investment decisions that these monopolies have made look a lot more like attempts to control influence than they do to participate in a liberal, cooperative international system where gains from trade are what everybody is trying for. So if we're at war, if other countries are not participating in a liberal world order, it changes a lot of things, because then size alone is bad. There is a problem. Us refusing to do business with them, even if it harms our consumers. Because remember, the argument for free trade is unilateral. The argument for free trade is unilateral. We are better off if we cut trade barriers, even if other countries don't, because it's better for our consumers. They're saying, here's some really cheap stuff. And we say, no, no cheap stuff for us. You would be better off having it. Well, imagine that it's June 4th, 1944. And I make this argument to General Eisenhower. Now, he's pretty busy because they're about to invade in Normandy. And I say, General Eisenhower, the argument for peace is unilateral. If we do not invade Normandy, a bunch of our soldiers will have their lives saved. And they'll say, well, you're a moron. This is war. Of course soldiers are going to die, but we're going to kill more of their soldiers. It's about relative gains. War is about relative gains. It's not about absolute gains. If you think we're at war with China, I happen not to, but it's not an implausible argument. If you think that we are potentially at war with China, then buying stuff from China means that China's power is being increased by more than ours. And my antitrust solution of not breaking them up, it doesn't apply. I may just be wrong about that. So that's a really good point. The book, as I said, is called Wireless Wars. It's a really interesting documentation of the history of 5G in China.
Even if this legislative trend is real and not just transitory, say multi-administration, is it possible that the judicial level will strike these down by staying with the Borg standard? So that, yes, it's a risk, but if any of these companies have the gall to defend themselves, the giants, in court, they could be vindicated because the courts themselves have not adopted this standard. They still have, presumably, the status quo Borg standard. Do you think that's possible?
It's not only possible, it's likely. And that's really the reason that I think it's the best that we can do. I mean, I was rude to Roy, even though I agree with him, or maybe because I agree with him, that we'd be better off without antitrust. Courts, by their nature, are conservative in the sense that the most they can do properly is to defend the status quo. And in this case, we have a status quo. And it is quite likely that attempts to change this there will be some problem, except, let me point out the flaw in my argument. We're not talking about the Constitution, we're talking about the Sherman Act. If the Senate Democrats are able to pass a new act, which does in fact contain what they think is the original intent of the Sherman Act, then no, the courts will enforce the new law. Because this is not a constitutional claim, even though it should be, because the 5th and 14th Amendments should imply freedom of contract and non-interference. Our economic rights should be just as large as our political rights, but that's long gone.
So you don't interpret these legislatures as just trying to get the current Justice Department to change its guidelines. You think they're actually trying to amend the
No question.
existing laws?
They want to pass a new Sherman Act. It's 7:15, we may have had all the fun we can have.
Just really briefly, thank you very much for coming. Please look for us on Facebook and Twitter.
MySpace, they've got a nice MySpace.
We haven't done MySpace. We're on Instagram and we're on LinkedIn. I hope you had fun. I hope you learned something more than if you just stayed home and watched Prime or something.
TikTok.
It was my head was hurting there for a little while, so I know it was a great speech. Thank you very much.
Thank you.
Oh, by the way, please get a name tag and be sure to write your name so that we can all greet you again. Thank you.